Good morning. I'm Diane Macedo. Thanks for streaming with us. In today's update, President Biden will deliver his first address to a joint session of Congress tonight. The speech will focus on his $1.8 trillion plan for what Biden calls human infrastructure, which he says will be paid for by a tax hike on the wealthy. The plan includes $200 billion for universal pre-K, 2 years of tuition-free community college, $225 billion child care for low-income working families, and paid family and medical leave for up to 12 weeks. Health officials say vaccinated people no longer have to wear masks outside unless they're at a crowded event. The CDC is giving vaccinated Americans the green light to exercise outside, attend small outdoor gatherings, even with unvaccinated people, and dine outdoors with other households, all without a mask. The administration is hoping that relaxing guidelines for those who are fully vaccinated will encourage those who have not yet gotten vaccinated to do so. Meanwhile, the COVID crisis in India is getting worse. New cases there have topped 300,000 every day for a week. The healthcare system is collapsing under the pressure as the country faces a shortage of vital supplies, but the world is now coming to India's aid. President Biden says the U.S. will send medical supplies and vaccines. The U.K., Germany, Australia, and Canada are also pledging their help. And the family of Ma'Khia Bryant has hired an attorney to conduct an independent investigation into her fatal police shooting. Attorney Michelle Martin is expected to announce that investigation at a press conference this morning. 16-year-old Ma'Khia Bryant was shot and killed by police shortly after they responded to the scene. Body cam video appears to show Bryant lunging at a woman holding a knife when police opened fire. And a North Carolina judge is holding a hearing to consider petitions to release body camera video in the police shooting death of Andrew Brown Jr. Overnight, some demonstrators were arrested after violating a curfew after the family's legal team released new surveillance video in the case. Victor Oquendo is in Elizabeth City, North Carolina, with the latest.
Elizabeth City police in riot gear overnight as protesters defy a curfew, taking to the streets for a week straight after Andrew Brown Jr. was fatally shot by deputies. In this new video taken moments before Brown was killed, North Carolina sheriff's deputies seen racing down the street, piled in the back of a truck, speeding up to his home. They say with the intent to serve a warrant for drug charges. You can hear them shout commands. Moments later, he was shot and killed.
It looked like a hit squad. Deputy sheriffs with weapons, fully loaded, pulling up on a citizen.
Despite growing calls for transparency and mounting pressure, the body camera video from those deputies has not been made public. Brown's family says they were only shown 20 seconds of footage from a single camera. On Tuesday, his family and their lawyer releasing an independent autopsy, saying he was shot 4 times in the arm and once in the head.
It was a kill shot to the back of the head.
The state releasing his death certificate, confirming he died in minutes of a penetrating gunshot wound of the head. The family says the shooting happened as he was trying to drive away. Their attorney says no weapons or drugs were found in Brown's car or in the house at the time.
A black man, unarmed, a bullet in back of his head for no reason whatsoever.
Andrew Brown! And Victor Oquendo joins me live now from Elizabeth City. Victor, a judge is holding a hearing right now on whether to release body cam footage to the public. The family has been calling for this. The sheriff has said he wants to see this happen, too. And we understand that the family is in attendance at that hearing. What's the latest on that?
Diane, we just learned a number of new details here. The district attorney spoke at length just moments ago. He said that he wants the video, all body cam video, to be released to the family of Andrew Brown Jr., but he wants this to be delayed for 30 days. He's asking for this delay so that the investigation into the shooting can be completed and that they can review all video and witness statements. And it was also very interesting when he described at length the body cam video. He said that the video shows when deputies arrived at Andrew Brown's house, Brown was inside his car and the car was stationary when they arrived and started shouting commands. He even says deputies tried reaching for the door handle and the car was still. It was at that moment, though, that Brown started to reverse and made contact with law enforcement officers, and then from there moved forward and again made contact with law enforcement officers, and the district attorney says that's when shots were fired. That's something that we have not heard yet, and he also took issue with the way one of the attorneys for the Brown family legal team described the portion of the video that they saw. Listen to what else the district attorney said moments ago.
Your Honor, statute then moves down for the considerations that the law enforcement agency is to consider upon disclosure to one of these enumerated persons. Of course, that person has to have standing. It has to be one of the enumerated persons under the statute. Then the law enforcement custodian needs to consider whether the information is confidential. Does it contain information of a highly sensitive or a personal nature? Would releasing it cause harm to someone's reputation or jeopardize their safety? Would releasing be a serious threat to the fair, impartial, orderly administration of justice? And does confidentiality necessitate the protection of an active criminal investigation? So those are the factors for the individual law enforcement agency to work through as they're thinking about disclosing to an individual person. We're here for release, a petition for release.
And that was a clip from that hearing in Elizabeth City, North Carolina. It's actually still going on right now. The judge there is going to decide whether or not to release the body camera footage of that police shooting of Andrew Brown Jr. So let's listen into what they're saying now.
Records of criminal investigation. The legislature has set us at least somewhat straight in that regard. They're not public records, but this is the process that everyone is given to seek their release. And that's the court with the opportunity to review them and apply the factors that the court thinks is appropriate. As we've stated in the brief, and I'm assuming Your Honor has read the brief.
I have your brief and the attachments, and I have reviewed.
Okay, thank you. The radio traffic indicated that Mr. Brown had been shot in the back, which also adds interest in this under the circumstances. Mr. Womble's recitation of what happened, which stands in stark contrast with the family's attorney's representation of what happens, to me is absolutely compelling to release it. Everyone can have their opinion of what happened. The video may or may not show what happened or how it happened. And so releasing that will provide the information. The best vaccine to rumor is fact, and it shows the facts of what they are, or it may not. I have been, as I've said, I've done a number of these, and I've been in circumstances where somebody in an incident like this is claiming excessive force or something like that, police saying it didn't happen. And both results have happened. The video gets released and it supports the claims of excessive force, or it absolutely refutes the claims of excessive force. I have also had situations where it doesn't tell. It leaves it to be concluded. All of those things are important. As we state in our brief, that accountability is important, but in order to hold public officials accountable, one has to see what's going on, and this is very evident of that. I'm sure Your Honor is aware that in Minneapolis in the George Floyd situation, that the original police report indicated that Mr. Floyd had a medical incident and that caused his death. If it weren't for the folks standing beside, I don't know if we would have ever known what happened in that case, and certainly Your Honor is aware of how that played out in the last month, well, even last week. That's the type of stuff that we as citizens, in trying to hold our public officials accountable, it's information. I have seen videos of officer-involved shootings. I remember one from Moore County. It was a hailstorm of bullets. It was very disturbing to watch. And I remember that it struck me again how difficult law enforcement's job is when a young deputy turned around and he was absolutely terrified of what had just happened. And it was important for me to see that and the public to see that so they understand how difficult this job is. It's also important for law enforcement to see how their interactions with the public have an effect on people. It is part of that conversation. Your Honor, we do not believe that the release of these recordings will jeopardize an ongoing investigation or the pendency of any charges. There are none pending. Apparently, there are active investigations. You will see in the orders that we've attached that these videos just like this have been released as investigations are ongoing. It's my understanding, and I know representatives of the SBI are here, that the director of the SBI has indicated that he's taking no position but certainly doesn't object to the release. If they're the investigating agency, I think that adds a lot of weight. And I hear Mr. Womble that you can use certain types of evidence to test the credibility of people. I've been around the block, you've been around the block, to believe that people involved in this situation aren't talking and haven't talked to one another and aren't comparing notes of what they think happened. It is just not accurate. It's what happens in these situations. It happened, I'm sure it happened immediately, as it's happened immediately in every one of these videos I've seen released. What happened, it literally starts right at the moment of the shooting and continues on. That's not going to change the facts. This was done in the open. Nobody had any expectation of privacy, be it the officers or Mr. Brown. And then, in addition to that, Mr. Womble has argued, and Mr. Williams has argued, that the names of the faces of the officers involved should be redacted. Certainly, that's within your purview, Your Honor. I know my clients have been asking for the information that is absolutely public record under 153A-98 with respect to the officers of the Pasquotank County Sheriff's Department. And so far, that information has not been produced. And as Your Honor is aware, in our brief, we list that information. The names of these officers are going to come out because they have to give that public information. I don't want to be back here in a public records fight. There is no legal justification to withhold the information that the General Assembly has made public. If that information is out, then there's no reason to blur the faces of the officers. I am deeply disappointed, and I completely understand of threats being made, but the release hasn't been made, and there are already threats. I don't know how releasing it is going to change whatever somebody's motivation is to make additional threats or that sort of thing. And Mr. Womble, I believe it was, or maybe no, as Mr. Williams indicated, that somebody who didn't do anything wrong might be thrown into that pile of people that did. Well, releasing the video and seeing who did or didn't do what will work to alleviate that. Keeping it secret keeps the group of people unknown, and thus people are going to do what people are going to do. You experienced and you talked to us in chambers about the security. I'm looking around and there's security all around me. There was security. I couldn't even get parked near the courthouse. And if that's what needs to happen, that's what needs to happen. I know that you have a security detail. I know that others do. And if that's what needs to happen, that's what needs to happen. With respect to the pretrial publicity, the court is well aware, and I'm sure you have access to the School of Government's bench book on pretrial publicity, and there's a whole host of things that a presiding judge can apply to deal with pretrial publicity other than sealing a particular record. I can't speak to the wisdom of what they did, but through this process, the General Assembly has made these recordings, which are now in possession of the court for in-camera review judicial records. And there's a well-established First Amendment right for access to judicial records. And any order sealing those records must be reviewed under strict scrutiny. And we don't think that such an order could withstand strict scrutiny.
But I'm not being asked to seal records. I'm being asked under the statute whether to disclose records.
And I get that nuance, Your Honor. What I'm getting at...
That's not a nuance. That's a pretty bright line exception or difference.
I understand that. What I'm getting at is the General Assembly has seen fit to put these records and make them judicial records. And thus there are First Amendment concerns that then attach to those records because they now are judicial records. And so by not releasing them, we think that's tantamount to a sealing order or perpetuating their being sealed. I don't mean to be pejorative in using the word nuance. I just think we have a difference of opinion, and I respect your understanding. The other aspect is the notion of delay. And if there's a First Amendment right to these recordings, that every day that they are not released harms that right, and it's irreparable. And so release, that weighs in favor of release. It appears, if I understand correctly, that the sheriff is in favor of release. The SBI doesn't take a position and doesn't object to it. The Brown family is in favor of release. and it's the district attorney and Mr. Williams and his unknown clients who are objecting to release. Our partner Hugh Stevens just finished an amicus briefing in a Supreme Court case here in North Carolina, and the name of it is not coming to me, but it involved an anonymous case filed in Cumberland County. Dovido. So there you go. Where we and others challenged the fact of proceeding anonymously. I don't think you can do that under North Carolina law. If Mr. Williams is making an appearance, he needs to identify his client for the court. Certainly I understand the practical reasons why he's not doing that, but I don't think he can do that under the Dovido case and comport with North Carolina law. If he identifies his clients, again, all of the reasons to blur and withhold the public records regarding the officers of the Pasquotank County Sheriff's Office fall away. And so I think that's important. There are no charges. Lastly, it is my understanding, and it's happened in the vast majority of these cases that I've done, is the recordings capture transmissions of law enforcement broadcast over the public airwaves. Under the public records law, that is unequivocally a public record, and it would take law enforcement coming to make a motion to have those not released, and they have to bear the burden of that. I don't believe any such motion has been made in response to our petition, and so I alert the court to 132-1.4C4. Your Honor, it wasn't argued here. I'll throw it so the court understands, because we may get there. I don't know the circumstances of what other first responders came to the scene. Others have argued that there would be in violation of HIPAA. And here, law enforcement, we provided you in a brief, law enforcement are not covered entities. Their receipt of protected health care information in the discharge of their duties does not then lead to them. In addition, as I've said, this happened in the public view, I believe, in the public street. And so that there wouldn't be any HIPAA attachment, or that right of privacy isn't involved. Your Honor, as I started saying, the eyes of the world are upon us. And whatever these videos show, it will show them upon release. And people can draw the conclusions that they want to draw from there. I am not aware of any instance in North Carolina where the videos have been released, whether it's in an officer-involved shooting, police chase resulting in a crash and a death, and a claim of excessive force, where a judge has determined after their release that a juror or a defendant couldn't get a fair trial, or and thus prohibited the district attorney from proceeding with the charges. I've not heard of a case where a court decides that the usual arsenal of things that a court has at its disposal to deal with pretrial publicity are ineffective because of the release of the videos. I don't say this because past experience doesn't necessarily predict the future, but I believe in these cases, we've obtained release in all of them. There have been redactions, and there have been blurring and things like that. One judge ordered the blurring of a minor child's face at a shooting scene. We've blurred people sitting in a booking area as somebody is being processed and that sort of stuff. What I urge you to consider, if you are thinking about those things, is that hard cuts on video lead to speculation. Minimal blurring to protect people who are truly uninvolved makes sense, and it doesn't lead to the speculation. We have also had situations where a witness is giving an officer somebody's cell phone number or other contact information, and we've muted those so that somebody's personal information isn't being given out. We're respectful of that. I think, not knowing what's on the video, I think you can craft an order that addresses those things but gives the public as much information as possible so that they can have a better understanding of what transpired here in Pasquotank County. Do you have anything to add? With that, Your Honor, unless you have any questions.
No, sir. Thank you.
Thank you.
All right. With regard to this this petition, Mr. Womble.
And I'll be brief because I know Your Honor appreciates brevity. I just don't like being misquoted. And I stood up here and I did not say that there was not a public interest. I clearly said that public accountability was a public interest. I said that. In this case, it is outweighed by my responsibility to conduct the orderly administration of justice and also the potential rights of the accused or potential accused to a fair trial. It's outweighed. As counsel clearly stated, people will, his words, draw conclusions. That's what they're going to do. They're going to form and express opinions about what they've seen. And the video is the ultimate issue. This is not a tangential video. I don't know the ones that he's described. He's described the 30 or 20 odd times he's been around the state to obtain videos. I don't know what they show. I don't know that they go to the ultimate issue. I have no idea. In this case, they do. So potential jurors in the 1st Judicial District will draw conclusions according to his words. They will form and express those opinions. It will hinder the orderly administration of justice, and it will hinder a fair trial. Counsel pointed out that no case has ever decided that you couldn't get a fair trial. Well, maybe they weren't articulate attorneys. Maybe they held the trial somewhere where they don't have internet. I don't know. What I do know is that you cannot swing a skunk in front of a group of people and then ask them not to smell it. What I've asked is disclosure and release. I want Your Honor to give me an opportunity to complete this investigation, or the SBI to complete this investigation. Let me review it, make my decision, and then everybody can Monday morning quarterback me. Thank you, Judge.
Mr. Williams, you have anything you want to add?
Yes, Your Honor. Maybe there's something I'm missing here, and I miss a lot of times.
Mr. Williams, I don't think you missed that much.
I'm reading the statute 132-1.4a, and in subsection C, it names the people who are subject to disclosure, to whom it may be disclosed. They include a person whose image or voice is in the recording, a personal representative of that person, a personal representative of a minor or an adult under lawful guardianship, a personal representative of a deceased person whose image or voice is in the recording, or a personal representative of an adult person who is incapacitated. And then you go to the section F, dealing with release. And it says, notwithstanding the provisions of subsection G, a person authorized to receive disclosure. The media is not a person authorized to receive disclosure. A person authorized to receive disclosure, and then going on, may petition the Superior Court for an order releasing the recording to a person authorized to receive disclosure. The court shall determine if the person to whom release of the recording is requested is a person authorized to receive disclosure pursuant to subsection C. I submit to Your Honor that the press does not have standing and is not covered by this statute. At the end, if in fact you order release with a delay of 30 days, then they can get it when it's released then. And we would ask you to deny the request, and then I would renew all of my prior arguments on the county's petition as well.
All right. Thank you, sir. Mr. High, I know that you were a party, your county was a part of this. Do you want to be heard with regard to this issue?
Just briefly, Your Honor, thank you very much, and good morning to you.
Good morning.
For the record, I'm Hackney High, and I'm here on behalf of the Clemens County Sheriff's Office. And as Your Honor well knows, that is a county that's located adjacent to this county, just west of us. Elizabeth City is not within the jurisdiction of the Clemens County Sheriff's Office, but shortly after the shooting, our office received a phone call requesting mutual aid assistance over here for crime scene preservation, for security, for crowd control, and the like. Due to certain budgetary constraints, we are a very small county, a very poor county. We don't have body cams. And none of the officers that came to assist local law enforcement were equipped with body cams, and we don't have any recordings of any of the events that we witnessed while we were here providing that mutual aid assistance. I just want to be clear for the record, there is nothing that we could release because we don't have cameras and there were no recordings made. And accordingly, I would just ask that the Sheriff's Department of Clemens County be released from this proceeding and any further obligations that it may have.
You want to be heard with regard to that?
No objection, Your Honor.
Okay. I'll grant that relief.
Thank you, Your
Draw an
Honor.
order.
I appreciate it very much.
Yes,
Thank
sir.
you.
All right. Anything else?
Your Honor, just to address Mr. Williams' point, I want to make clear that the court is aware that the petitioners, my clients, the 20 media entities, have petitioned under 132-1.4 subsection G, which is the general release provisions. F is reserved for those entitled to disclosure and law enforcement. A major difference between F and G is those petitioning under F, which could be law enforcement or those entitled to disclosure, don't have to pay the $200 non-refundable fee. My clients paid the $200 non-refundable fee. Other than that, Your Honor, I would also say that with respect to speculation, the speculation and conclusions are going to be drawn whether or not they're released. We believe that release will be, as I said, will quell the rumors or deal with rumors or vaccinate the rumors because it will be facts that will be released. Thank you, Your Honor.
All right. Yes, sir. Yes, sir.
Your Honor, I want to clarify one thing. Mr. Williams waived notice today, and I want to tell the court that he has, of course, not seen this petition today, and I want to apologize to him because I don't think we were sure if this was under F or G, and I do understand in G, so to the extent I caused any confusion to Mr. Williams, I apologize to him publicly, and this has just happened at a very quick, fast-paced. I think we're all learning a lot very quickly. As to the public records request, I've been inundated with public records requests, and I understand there'll be a time and place, and we do intend to address those, but I can't tell you how many I've received. So, again, sorry to Mr. Williams, and thank you, sir. Thank you.
All right. Well, certainly we're not here today on public record requests, so we'll reserve that for another day. All right. Anything else? Yes, ma'am.
Your Honor, Amanda Martin, also for the petitioners with Mr. Toddy. As Your Honor knows, we served last night and have filed a petition asking the court to address the scope of the curfew that is embedded in the Elizabeth City declaration of a state of emergency. And as Your Honor suggested, I have spoken this morning with the city attorney. We have communicated about this, and I asked him if he was comfortable with me to put this on the record since he is not here, and he responded, absolutely, he is comfortable with this, that it's the position of the city that working journalists will not be subject to the curfew, and that he's not sure yet whether that will be through an amendment to the order or whether it will be through a working understanding and application of the existing order, but that he was comfortable with putting it on the court record that working journalists will not be subject to the curfew that is part of the existing.
All right. Well, that's absolutely something. There's nothing before me in order, anything before me, so I don't think I need to comment on any of that. You can continue to work on it, and if y'all can reach a resolution, that's fine. If not, and we need to take action on your motion, then we can do so.
I don't think that will be necessary.
Okay. All right.
Thank you, Your Honor.
Thank you. All right, so here's what I'm going to do. I would like to be at ease for a few minutes. I'm going to go back in chambers and put these matters down and render my decision, and I'll be back out to do that in about 15 or 20 minutes, okay? And we'll be at ease until that time.
Your Honor, I don't mean to be presumptuous, but I did prepare with the caption for our petition the Form AOC order.
I'm happy to take that and look at it. Yes,
there are 4 basic blanks.
Thank you. All right, anything else before we, all right, we'll be at ease for about 15, 20 minutes.
Thank you, Your Honor.
Court be at ease about 15 to 20 minutes.
All right, there's the court in Elizabeth City, North Carolina, taking a 15 to 20-minute break while the judge decides whether or not to publicly release the body camera video in the police shooting of Andrew Brown Jr. I want to bring in Law and Crime Network legal analyst Terry Austin and our correspondent Victor Oquendo, who's there in Elizabeth City, North Carolina, with a little bit more on this. Victor, there was a lot of kind of legalese spoken there, and Terry, I'm going to go to you in a second to help us break that down a little bit further. But Victor, it sounds like the big headline here is that both the family and the media are petitioning the court for release of this video, while we heard the district attorney say that he wants essentially more time to complete an investigation before releasing this video. And we heard an attorney for, it seems like, the police say they believe this shooting is justified and don't want this video released as well.
That's right, Diane. There are 2 separate petitions here, and you summed that up well between what the DA said and the attorney who we believe is representing the deputies here. Let me read you that full quote, what he said about the shooting being justified. He said that the officers are very distraught over what happened. They feel for the family of Andrew Brown, but as Mr. Womble, that's the district attorney, described to you, we believe that the shooting was justified. We've not heard anyone say that over the last week. What the district attorney was asking for was that the video should be released to Andrew Brown's family, but he's asking for a delay for 30 days to complete the investigation. By the way, as the judge takes the 15 to 20 minutes here to make his decision, I should tell you that early on in the proceedings here, he did say that he watched the body cam videos himself for hours last night. Diane?
And Victor, it sounds like from the proceedings that there's some disagreement over what those videos show in terms of what the attorneys here are saying versus what we've heard so far from Andrew Brown Jr.'s family.
This was pretty revealing, and it came again from the district attorney. What he says that he saw in the body cam video was that when deputies arrived at Andrew Brown Jr.'s house, the car that he was inside of was stationary. When deputies approached, they even got their hand on the door handle. The car was still stationary, but it was at that point that Andrew Brown reversed, hitting officers, and then went forward, hit officers again, striking them, and that is when they opened fire. Again, that is according to the district attorney. That's something that we've not heard yet, and of course we haven't seen yet because the body cam videos have yet to be released. But once the judge makes his decision, we should have a better idea on a timeline if and when that might happen.
Yeah, and the judge has said he's going to make that decision today. He said he's going to take 15 to 20 minutes right now, so we could have a decision that quickly. And I want to go to Terry Austin now to break this all down a little bit further from a legal standpoint. Terry, first of all, what we're hearing from some of the attorneys is whether or not releasing this video could prompt threats on the deputies and whether or not their faces should be blurred in this video. What did you make of the arguments on both sides there?
I think the argument for disclosure is really the better of the 2 arguments. I mean, the issue here from a legal perspective is the public interest versus whether or not there's going to be a fair trial at the end of the day. Obviously, there are concerns like safety for the police officer or privacy concerns, but I think those concerns are lesser than the concerns for the public interest here. The interest here is to make sure that what we are seeing is policing that is fair, that there's no bias, and the video will speak for itself. I think the judge has a lot to try to consider within these 15 minutes. He has to consider, one, whether to disclose it and whether or not it has to be edited in any way. And as I look at the editing, I think, should it be cut down? Should it be blurred? I mean, these are a lot of issues that he's going to have to look at and decide. And I think 15 minutes is pretty fast decision here. And, you know, frankly, I would rather take a little more time the fact that he's saying that he's going to do it in 15 minutes makes me think he might lean towards disclosing it. I think the arguments that the prosecution has, saying that they need time, that it's going to affect the charges, that it's going to affect the investigation, I think those arguments are not as sound. And I think we heard on the opposing side the fact that, you know, we really need to see what happened, and that is not going to really affect the charges. There are so many other issues that the prosecution has to look at beyond the video, and the video is what the video is. There's not going to be any delay if we disclose or release this video. So, frankly, if I'm in the judge's position, I would release it. I think more jurisdictions, we've seen across the country, more jurisdictions are doing exactly that.
And Terry, what do you make of this other account now that we've heard from the district attorney about what's actually in that video, what happened that day, and his plea to the judge to essentially release this to the family, but give me more time to complete this investigation before you release it to the public?
Yeah, you know what? I think, Diane, that argument isn't really solid, because what are you doing to the video? Why do you need to redact it? I mean, we've already seen that the family said, why are we getting just 20 minutes or 20 seconds? And I think that is a good question. Why aren't we getting the entirety of the video up to what led to the shooting, so we can see exactly what was said by the police officers, so we can see exactly what the individual did? What did Brown do? What was he doing at the time that he was being shot? And so I definitely think that taking the time to edit the video, what is the point of editing, redacting? Obviously, blurring is a point of, you know, I think it makes sense if, in fact, there are children there, et cetera, or if there's something even particularly gruesome. But frankly, I think the bigger issue here, Diane, is transparency. And so I don't think it makes sense for the DA to say that they need time, certainly not 30 days to redact a video. We know that with technology, if you need to make it a little shorter, say it's 20 minutes, you need 10 minutes. But we know also that the video is turned on when they're approaching the scene. So why do we need to cut it? And I don't think that the situation here is that it really needs to be blurred. From my understanding, there weren't any children in the area. So I think that the judge should look at those arguments and really decide in favor of the transparency.
And Terry, another thing we heard from the DA here is that people are going to draw conclusions. And he said that as if it's a bad thing. He actually quoted, "You can't swing a skunk in front of a group of people and ask them not to smell it." I wonder if they're entertaining the possibility of showing the full video to the public and presumably telling the full story as far as they know at this point, then why wouldn't it be okay for the public to be able to take that complete information and then draw conclusions from it, instead of what we're doing right now, which is drawing conclusions from the family's version of events that comes from 20 seconds of video?
Absolutely, no question about it. And when he made that quote, the first thing that I thought about was, why is the full video like swinging a skunk? The full video is the full video. It is the truth of the matter. It is exactly what occurred. And are you trying to change the smell of that skunk using his hypothetical? I think that really makes people begin to think, what are you trying to do here? Are you trying to pull the wool over our eyes? It is what it is. So obviously, once it's out, you can't change it, but it is what it is. And so you want the public to come to the conclusion of what they actually saw. They're going to draw their conclusion based on what actually happened. And if, in fact, we have some redacting or blurring or changing or editing of any sort, I think that is the problem. And I think we need to see what occurred, and we need to see it in its entirety.
All right, Terry Austin and Victor Akendo, thank you both.
Thank you, Diane.
Thank you, Terry. And that does it for this ABC News Live update. I'm Diane Macedo. Thanks for joining us. And remember, ABC News Live is here for you all day with the latest news, context, and analysis. I'll see you back here for that judge's decision in Elizabeth City, North Carolina in just a few minutes. And then Terry Moran and I will be back at 3 p.m. Eastern to break it all down for you on The Breakdown. Stay safe, everybody.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.